has at its root this understanding of fairness, particularly fairness for those who can't otherwise defend themselves because they're minorities or because, in the case of a land use application, they are just a single person, right? And those minimal protections are notice, hearing, decision maker, and reasoned result. And that's 4. That's it. Is it just 4? Yeah. Everyone's in the same. I thought it was 5. I thought I had 5 down there.
Parties?
Oh yes, that's right. Parties. They have to be a. Well, it's not really a 5 protection, but there were 5 elements. One saw in my brain. So yeah, these are the 4 protections that are provided to what we would classify as parties, people with a real stake or interest in the matter. So today we kind of build on that in talking about first decision making by consent and then decision making by referendum. So I'm marching down through my list here. I got to get through the end of this list. If I don't get through if I don't get through the end of the list, in other words, if I don't have a check mark next to your box, you lose 20% of your grade, right? So those of you that have not participated in the class discussion yet should be concerned, okay? Because you want that 20%. So I'm going to start asking around. I've got, I've got a list. I'm checking it twice, as the old saying goes. And so what I'd like to do is, Guang, can you talk to us about the Falconet case?
Yeah.
Versus Chicago? Great.
Okay.
What is this case about?
The plaintiff is, the question is the plaintiff, they want to get a permit to build a house for aged
Right.
in the apartment zone, but the committee is, but there is a requirement says that the people, they need to get the consent by the majority of the people who live there.
Right, and it's they call it a frontage consent requirement, and which is kind of an odd thing. But if this is the street, and then we've got the frontage of 2 blocks on the street, and this is where the project is. What this kind of consent requirement says is you got to get a majority of all the other owners that have frontage on that street. Or it was a majority of the owners on the frontage of that street to agree to this. And we presume that they were not able to get that, because if they were, they wouldn't have ended up in court. So they couldn't get the majority to go along, and now they're trying to solve their problems in the court system. So how does the court decide this?
The trial court said the requirement is valid, and the city approved that result.
Right, that actually the consent part, they go through all this background of a series of precedents, a line of cases on this particular issue, and comes to the rather curious result, I thought, that this was a valid regulation, at least from the consent point of view. Who do they end up siding with at the end? Who wins this case?
I think the plaintiff.
The plaintiff ends up winning this case, but for different reasons.
Yeah, right. Yeah.
And what did you catch what the reason was? Why does the plaintiff win?
Let me try. So that's to say, the final conclusion is based on first, because they built the house for the aged. It's not a public nuisance or something, and also the zoning ordinance for that apartment zone permit the next the nursing house, so like the home for the aged. So that's the federal conclusion based.
Right, it's not a public nuisance, which is to say that it doesn't threaten what?
The health, safety, welfare of the neighbors.
Right, doesn't threaten the health, safety, and welfare of the neighbors, and which is to say that, and the court realized this is an older case, right? Well, it's not that, no, it's only a couple of years older than yours, that's not that. Some mornings it feels old. But what is the ultimate basis for the decision of this case? Yeah.
Whether it's legislative, or no, sorry, not legislative, I get the word now, but whether or not the public can decide that, or it needs to be administrative.
Right. And what's the phrase? Yeah, close. That's related. Substantive due process, right. So this ordinance fails in the court's eyes, not because of the consent provision. In other words, not because of the reason that we're reading it, but because it is not a legitimate area of government regulation, at least as applied to this particular applicant. Maybe applied in other circumstances, okay. But as applied to this particular applicant, there is not a legitimate health, safety, and welfare concern with having a retirement home. The language here is interesting. Home for the aged. What was it? Another one was an old ladies' home or something. We would call it a quality retirement community. What we would call it today. That this is not a legitimate matter for government regulation. It's not within the government's police power, and there's not a rational decision being made here. So that's not the reason we're reading this case. We're reading this case for the stuff that came before on consent, and the whole idea that the people who live here, and here should be able to decide what this person can do with their property. That's the reason we're reading this case. And as you say, Guang, the court said this ordinance is fine on those grounds. But they give us a little rule, and because this is a scan of my version, you were able to get the benefit of my margin notes. And so what did I mark down in my margin notes as the rule? And by the way, at this point in the semester, hopefully this is not like a big aha moment. Hopefully you've already come to this conclusion yourself. But if you haven't, now is a good time to say, oh yeah, that's what I'm looking for when I read these cases. I'm looking for the rule. And here it is. And what is the rule? With regard to consent. Did you catch that, Guang? Is there a problem asking whether your neighbors permit?
There is a condition for this situation, I think, as I see. It says if an ordinance permits a certain percentage of property owners to impose or create a restriction upon their neighbors' property by the device of consent provisions. Such limitation constitutes an invalid delegation of legislative power.
Exactly. So what do they mean by that?
It's not illegal to let the
Right. At least in the American system, who has the authority to pass legislation?
Elected officials.
The state legislature, Congress, the state legislature. At the municipal level, who has the authority to pass legislation?
the state.
The city council, right? Yeah, the city council at the municipal level, at the city level. The city council has that authority, right? Because the state legislature gave it to them.
Right.
And city council members are directly elected by the people. And under our system, legislative authority resides in the delegated, or the bodies that have proportional representation of the people. So what's wrong with allowing these people to decide what happens on this piece of property?
So that means that this private individuals to use the legislative power. So that should be the city council. It's not
The city council, yeah. Who elected these people? Nobody elected these people. They just happen to own land on this street, right? They are not responsible to the electorate. They are not responsible to the people, and therefore, an attempt by the city council, which is the legislative body, which has legislative authority to delegate, to kind of outsource this decision-making process to people who are not elected, is unconstitutional. It's an unconstitutional delegation of power to people who are not authorized to exercise that power. And that's the main reason we read this case, is because, and if any of you ever seen a consent provision before, they're all over the place. They're very common. You can say, well, how could that be? I'm going to tell you something that is going to just scorch your ears. You'll be so scandalized you won't be able to walk out here without being able, you won't be able to walk straight. Let me tell you, there are unconstitutional provisions in zoning ordinances right now. In this town.
That's it. Thank you.
Oh my gosh, I know. You've never heard such a thing before. It's true. Now, I'm not saying that every provision that requires neighbor approval is necessarily inherently unconstitutional. But I will say that it's suspect. Now, yeah, Darby.
So, yeah, that was what I was going to ask. So it points out here that if they're allowing an exception, then consent is acceptable, whereas if they're creating law, then that's when it's not.
Yeah.
So is that
Right. Right, so the distinction here is they're trying to make a distinction here based on this legislative administrative split. If it's making law, if it's legislative in nature, and we talked about those sliders, if it's legislative, if it's more making law, if it affects a broad number of people or a large amount of land, it's more likely to be administrative if it's applying law, or if it's affecting few people or specific targeted areas of land. And what they're trying to do here is to make a distinction. They're trying to say, well, if it's legislative in nature, then it's inappropriate, it's illegal, it's unconstitutional to allow people who don't have the authority to exercise that power to make the decision. And if the city council is too chicken, to make these hard choices, because that's essentially what they're doing here, is they don't want to make the hard choices because it's going to upset the neighbors, and they don't want to do things that are going to upset people that elect them, and so they say, well, we'll just let the neighborhood decide because we would rather not touch that one. It's like touching the political third rail, as they say. It's just too electric for us, and so we'll let the neighborhood decide. We won't make a decision. And what the court basically is saying here is, you don't have that option. That's why you guys get paid the big bucks. Under your table usually, but it's your job to make the tough choices about what's appropriate, what's consistent with the community's health, safety, and welfare, and what isn't. And you just can't outsource that to people who don't have the authority to do it. Now, when it comes to administrative decisions, things that are not legislative, they're not making laws, Then, if it's just administrative, well, we have unelected people making administrative decisions all over the place, and that's fine. Because if you're making an administrative decision, you're just applying the law and affects a few number of people and a few acres of land. And so they make this distinction. Well, if you're asking for people's approval, the neighborhood's approval, to set the standard. There's a good example here of another case that's referenced here about establishing a setback line. We're not going to set the setback line. We're going to ask the neighborhood to establish their own setback line. If you're asking or requiring the neighborhood to make the standard, that's clearly legislative. That's not allowed. If, on the other hand, you make a decision and then allow the neighborhood to waive the application or the enforcement of that provision, then that's all right, because that's administrative. That's an administrative choice. It's called prosecutorial discretion. And that's perfectly legal to allow the neighborhood to make that choice. You think, oh, okay, I get that. Now tell me how you tell the difference between those two. I mean, sometimes you can come up with examples that are clear, but there's an awful lot of gray. You know, to whether, well, what I loved it, my brush with this kind of thing was when my neighbor, this is back in Portland, my neighbor next door, the one that has the dog that is never in the fenced yard in the back, is always running around loose, and is awfully fond of my front yard for one particular function. And by the volume, I can only assume that that's the only place he goes. And you know, I grew up with dogs. When I was a kid, my family had pedigreed Dalmatians, and the ones with the brown spots, which are recessive. And by the way, I advise against ever owning a Dalmatian, especially the brown spotted ones. They're too inbred, and if it's a recessive gene, that means they're really, really inbred. They're skittish and all sorts of personality problems, really bad with small kids. And I was a small kid, and we had them all over the place. I loved them; they were great. And of course, this was, you know, when 100 Dalmatians was, you know, big in the theaters and so forth. And so it was so much fun. They're so cute. And you know, the spots when they're born, they're all white. Spots don't come in for about a month. And so we had 33 of them.
Oh my gosh.
Not all at once. We had 4 different litters. Anyway, I've dealt with a lot of dogs and the things that dogs do. But when it's your dog, at least you're getting something for it, right? When it's somebody else's dog, you're just getting, well, you know. And so this is the guy next door, and we've talked about his dog. No change in behavior. And he comes with this form for me to sign that will allow him to have a horse. And I'm thinking, oh man, we're talking big volume now. The horse is going to come over here too. And I just thought, you want, and he was strategic about it. The law was that he had to get approval from all of the owners of property that border on his. And he's on the corner. And so there's only, and there's, I don't know what it is about the next house to the other side, but he only has one neighbor that is right up against his property line. It's me. And all the other abutting property owners are actually across the street, you know, across from his front yard. So he comes to me, you know, he comes to me last. That's what he did. He goes around to everyone else who's no problem having a horse. Yeah, they'd be kind of, cool and quaint, and he comes to me last, and so everybody else is signed, and so I'm the one who's put in the kind of in the crosshairs, in the bad position. And I said, there is no way, absolutely no way. And it was a tiny lot. So he was not happy with me, but that was fine. He moved not too long after that. Yeah, the dog, they took care of the dog too. It was interesting. But this was a consent provision. And so I think, and I don't know what the actual standard was. It was a county provision. We're in the city, but the county regulated horses. And I don't know if it was a technically consent or waiver provision, where horses, you can imagine how it would go, right? If it were consent, using this maybe slightly suspicious dichotomy, if it were a consent provision, the horses would be allowed only if the neighboring property owners approved. If it were a waiver provision, horses would not be allowed unless all the neighboring property owners approved. And you may well wonder, what's the difference? And how could such an important distinction hang on such a flimsy distinction? The important conclusion, whether it's constitutional or not. It's constitutional if you do it the latter way, but it's not constitutional if you do it in the former way. And so if you read, I don't know if I scanned this, maybe I didn't, in the script notes after the case, the Illinois Supreme Court subsequently, in a subsequent case, no, I probably didn't scan it, in a subsequent case, said, this subtle distinction between creating and waiving a restriction cannot be justified. Each constitutes an invalid delegation of legislative power, where the ordinances, as here, leave the ultimate determination of whether the erection of the station, or in this case, what is being contested, some sort of gas station, whether the erection of the gas station would be detrimental to the public welfare in the discretion of individuals rather than the city. In other words, the discretion of people who do not properly have legislative authority. So, what do you take away from this as practitioners? A sense of caution. When you're out there as planners, the planners among you, be very cautious about any proposal that requires surrounding property owner, neighborhood consent. Because depending on how the court's feeling that particular day and whether they see your particular provision as being a waiver of an existing restriction or the creation of a new one, or just basic, being lily-livered and not being willing to take the hard choices, it might not go well for you. So what this does is it sets us up for the next case. Thank you, John. Taylor, you want to talk to us about Mapleton?
I'm going to have to pass.
Okay, that's your second pass, just FYI.
Okay.
Ahmed. Mapleton versus Friends of Maple Mountain versus Mapleton City. Now, you're not from here. Where is Mapleton, folks?
I'm Provo.
South. So you know where it is. Oh, there you go. So you know where it is. Okay. So why there's a focus here in the regulations on 30% slopes. Why are the people of Mapleton and the city council and mayor of Mapleton so concerned about 30% slopes? Yes, very good, very good. But historically,
What happens?
Yeah. Yeah, we've had in recent years some pretty horrendous forest fires just up the hill. And Mapleton, I don't know if Mapleton was hit as bad as Sandy Point. Sandy Point is another town in the same area. Sandy Point was hit really badly. There was a forest fire in the summer that wiped out the vegetation on the hillsides just above the town, and then the fall came, and the rains came, and the hillside came tumbling down. And floods and mud and slides and so forth. And so in this part of our state, which is, moderately populated, those kind of geographic, topographic considerations are of important concern. Okay, so what is our, there are a whole cluster of issues here. What stood out for you in this case, Ahmed, and how do we distinguish this from the prior case?
The Marrakech test?
Yeah, Maracas.
Marrakech test, which distinguished its administrative and legislative. And one of the things which I thought was important at the end, that they thought that the sequence was the issue here, not they thought would be looking at the balance is more important than looking at the sequence.
Right. But let's step back from the details associated with the Maracas test and ask the kind of threshold question: why does that matter? Why do we need that test? Why do we need to be able to distinguish between the administrative and legislative?
Because if it's legislative, then the public have the right to referendum.
Right. Right. This is this determines whether an issue, a planning issue, a zoning issue, can legitimately, constitutionally go on the ballot for a public vote. Now, we just got done saying in the Valkanet case that having unelected people deciding legislative issues is unconstitutional. Right? That was the thrust of that case, that you cannot constitutionally allow unelected people to decide legislative issues. And here we have a situation where they're saying that legislative issues can be decided by people who are unelected. How do you rationalize those two cases? How could both be true? Because they are.
If we're assuming that it's a waiver or that they're modifying it,
No.
rezoning, not considered.
No. Think about it. It's a scale issue. In the Valkanet case, who was, according to the ordinance, who was the city trying to allow to make the decision? Just the people in the neighborhood, yeah. And then Mapleton, assuming that this is a nonprofit group, Friends of Maple Mountain, assuming they get their way and they get to put this issue on the ballot, who will be making the decision?
The people, the citizens.
The entire city. That's important because the neighbors of the proposed retirement community in Chicago comprise how much of the electorate, how much of the citizenry of Chicago? Small, right? The people who will be deciding, assuming that Friends of Maple Mountain get their way, the people who will be deciding this issue include how much of the electorate in Mapleton? Every. Right. This is called direct democracy. Yes.
Does it matter more that it's like a referendum too, like a voting procedure statute rather than just like
I suppose that's true.
I'm just curious because I was just kind of wondering if reading, did you wonder if it's more like the setup of it? Because it seems like you're just going around asking people, and I bet there's a much more tendency to say sure. If that's true.
Well, I think that's the informality. That's the way a lot of people vote in elections too. I don't know that we could make if you dig down, I don't know if that distinction would really hold up. I think what's really at matter here is, again, scale and scope. Because when you ask, well, the members of the Mapleton City Council are selected by whom? The people of Mapleton, it's the same group, right? So whether the legislative action is being done by the representatives of the people, City Council, or by the people themselves, It doesn't matter. They're treated equivalently for legislative issue. It's a matter of legislation that the city has authority over, has jurisdiction to decide. States given it delegated power to the city to make these kinds of decisions about zoning and planning and things. They have the authority to make a decision on those subjects. They can either do it themselves, the city council, or the electorate can do it for them. And if the city council doesn't ask the people for their consent through some sort of election, there are provisions in state law that allow affected groups who are not pleased with current legal situation to be able to circulate a petition and put a matter or issue on the ballot for people to vote. So, okay. Why is it then is it important to distinguish legislative actions from administrative actions for referendum? This is not the case. This is just going to have to pick this one through.
Administrative action, they can delegate it to whoever they want.
Yeah. That's, well, this is restating what we just said. That only legislative actions, and this is why we have the Maracas test. This is the purpose of the Maracas test, is to distinguish those things from that are administrative from those that are legislative, because only legislative things can be put on the ballot for a vote of the people. Administrative things cannot. And I'm asking you why. Why can't we put administrative things on? Hold on. Well, think about what we were talking about last time with the Fasano case, and setting up the minimum standards for fairness in administrative actions. Why do we have those guarantees? To guard against abuse, right? Because, and why do we need those guarantees? Because people who are subject to administrative actions are usually individuals, small groups. They're minorities in one way or another. They are not the majority, right? So you're, let's see, you live in a historic neighborhood. It's been designated as a historic district by your city. And you want to remodel your house. And as part of your remodel, it's done this. As part of your remodel, you need to get approval for changing the windows on the front facade. Why do you want to do that? Well, because the old windows are, they're single pane, and they're leaking, and there's almost no insulating value. In the winter, they're cold. You're spending a mint in your heating bill. It's burning all this extra energy. You're an environmentalist, so you want thermal pane windows, triple pane. You want something that's going to insulate better. And you've got to get approval from the city. Why? Because you're in a historic district. Is that something you want the entire city voting on? Does somebody, on the other side of town, in another neighborhood, do they have any legitimate issue or concern or interest in whether you have new windows or not? Now that's maybe a simpler case. Now let's make it more difficult. You are a nonprofit. You run a nonprofit organization that is dedicated to providing housing for former convicted felons who are coming out of prison. And many of your clients are completely reformed and are ready to come back into society, but they are going to have some challenges, right? Trying to integrate and reorient into society. Your organization is playing a crucial role in terms of societal stability and regeneration. And you are seeking a permit, a a conditional use permit to construct what we would call a halfway house, a housing for people in this situation. And are you going to be a popular guy in your neighborhood? No. Do you think it's fair that you should have your permit voted on by everybody in the city? No. Right? And then now when you think about it, if it's an administrative action, what are we doing? We are applying law to a certain existing set of facts. And one of the things that we said that the due process clause guarantees us is a reasoned result, right? A statement of what laws apply, how they apply, given this set of facts to this circumstance with a nice reasoned result. Can you get a reasoned result out of a referendum?
Not really.
No! You don't get a statement of reasons, you don't get the application criteria, you don't get anything except just a thumbs up, thumbs down. That's it. So you're basically being denied one of your key rights, due process rights, by having an administrative action determined on a referendum. And so this is fundamentally the reason why we have this distinction and why we have tests like the Maracas test to try to figure this out. Okay, so now the Maracas test. How does the Supreme Court here determine whether a matter is legislative or administrative? Mm-hmm.
Whether the threshold to file property numbers is to the security satisfied. Number two, whether the views on the government is consistent with the general purpose and quality of the original zoning ordinance. Three, whether the views on the government is consistent with the original foundation of zoning law and the governmental unit. And four, the fourth statement.
What do you think about those as criteria? Is it good? What does notice have to do with this? I think it's a really clunky set of criteria, frankly. I read it and I go, what? You're kind of dancing around the issues. And, you know, and my frustration with this is such an important distinction. Every time you go to an APA, a state APA conference, how many of you been to the state APA conference? Do they have a session on law?
Yes.
Yeah, and did you go to it?
Yeah, they're highly desirable.
Yeah, they're usually packed. And did they talk about this issue?
Absolutely.
Yeah, every one of them. The first time you go to one where they don't talk about this issue, i.e. the distinction between administrative and legislative, will you please contact me? I'll be in retirement. I might even be dead, but you can contact my estate. My son will be very interested in hearing from you. But I swear to you, every time they get together, they have they get one of the attorneys to get up there, and this is always, it's not the number one, it's the number 2 or 3 issue on the little handout sheet they give. Because figuring this out is really, really important. And the Supreme Court keeps messing it up by stuff like this. This is actually an improvement over a couple of prior decisions. There was one here, Monty versus Sandy City, which was a Walmart case. Walmart was proposed, and it's down there now, to construct a new facility on the admin zone parkland. And the citizens who wanted to challenge the decision wanted to put it on the ballot. It went all the way up to the Supreme Court, and the Supreme Court really messed things up by saying, well, you know what, this distinction about whether it's administrative or legislative, we'll just determine based on the structure of government. What? If it's a mayor council form of government, then it must be legislative, because only legislation can come out from a city council with that kind of structure. And it was this form over substance kind of decision. So that every time they come back to it, they say, okay, this time we'll get it right. And every time they kind of screw it up. And it's easier for me to say, right? The professor up here on the hill, not having to be down there making real decisions. So Because you know, when it comes down to it, actually, the real issue is here. It's just buried under all this gobbledygook. And it's this one right here. The second one, whether the new zoning ordinance is consistent with the general purpose and policy of the original zoning ordinance. Are they making new law? Are they adopting new standards? Are they applying existing standards? Now, I understand that that's not necessarily a dichotomous situation, that there are shades of gray in the middle there. But usually, if you're taking an existing standard and applying it in some sort of new context, that would be applying law. And if you're changing the standard of an existing law, you're changing the standard of an existing zoning ordinance, that would be making law, that would be legislative. It's not that. So what do they decide here? What is this? Which one is this? Legislative. Of course it is. Because they're adopting a new provision in the zoning, a new district. They're creating a new district. Now, it comes up in the context of court proceedings to enjoin the application of this particular district to a specific piece of land. Actually, the application of that district to that specific piece of land would be what kind of action? Administrative. So it comes up in a slightly bizarre context. And the reason for that, if it matters to you, is that this was proceeding for an injunction, a preliminary injunction. And in order to get a preliminary injunction of any kind, you have to show your likelihood of succeeding on the merits of the case. So they had to show that they were going to be successful in their other lawsuit against this, or their lawsuit to get this on the ballot. And the reason they can get it on the ballot is because it's creating law and it's legislative. If you didn't understand that, I didn't really either. But they are focusing in on the fact that this is making new law. It's hence legislative. And if it's legislative, you can put it on the ballot and which people can vote. Now, this new zone, this new zoning district is probably going to be applied to only one piece of land, this piece of land. But it's still considered to be legislative because they're creating that new district, they're putting it into their zoning ordinance. And who knows, in the future, maybe there'll be some other piece of land that has a donut hole where they need to apply this same kind of provision. So did you catch the developer agreement angle here? Because that was a big part of the case that was underpinning all this, is that this was the result of the developer agreement. Did you catch the exaction that was in here? You say, well, wait a minute. Where's the essential nexus? That's not roughly proportional, right? But it's a developer agreement, right? And so if they had wanted to contest that, they probably could have, but they wanted their rezone, right? And so it was this kind of, give and take between the city. They wanted a new zoning district that would get them some more housing units. The city was interested in protecting the 30% slopes and getting a public right-of-way for this trail to go through, and a right-of-way for a water main. And so it's like, okay, let's make a deal. And we did. Citizens exercised their constitutional right to put this issue on the ballot, and at the end of the day, they had their say. Anybody know how this turned out?
So, they voted against it.
So the referendum succeeded, they voted down the reason. So what ended up happening to what's his name, Mr. Gibbons, or whoever it is?
I think I found something about both sides can do one or something. Because they city can't do all these special things. They have to go all the way back. And then, this is, I think, not built up both sides. And then,
So when reading this, I was just thinking, and maybe you were thinking it too, there's got to be a takings lawsuit somewhere in this system, right? I mean, you catch the provisions of this, the base zone, the pre-existing zone, what's it called, CE1, critical environment. In this zone, lands with 30% or greater slope must remain undisturbed in their natural condition, except for the planting of additional vegetation, the addition of sprinkler irrigation systems, the establishment of required fire breaks, or required access easements. Oh boy. What fun. So, what do you think about the takings potential of this zoning movement? Ryan? No? Why not?
That zone's put in place to protect the health, safety, and welfare of the city, their citizens. And so, and they can, there are spots on his land that they can develop. It's not like the whole thing's 30%. They can develop it, just not on certain areas.
Right. So at least as applied to Mr. Gibby's property, I think that's probably not taken. Well, at least not a white guy.
Yeah.
It's not going to be a Nolan situation. There are buildable lots.
The city of Macon did to solve this issue. They actually,
Here we go. The voice of
they actually created a transfer of density rights, and they would allow them to move the density off the hillside area down on the property. And so, they were able to keep saving on the density.
great. Well, this fits into our readings. Sorry, Roger has my only copy. On April 16th, transferring rights. Great. Cool. So let's use this, at least a few of these minutes here, to review what we know about the consequences of the distinction between administrative action and legislative action. We were to create a little chart. And these would a little table, and these would be our column elements. What would be our rows? What rows would we create? To show our understanding of the distinction between these two things, kind of the consequences of the distinction between these two types of action. Mike,
The scope, whether it's just one parcel on one end or whether it's the entire city.
okay, so what we're asking about now is not, let's assume that we know which is which.
Okay.
Because you're right, depending on whether you use Professor Bartholomew's patented formula, or you use the Maracas test of the Utah Supreme Court, we do have a way of distinguishing these two in perfect contiguous. So the question here is, after we figure that out, what difference does it make? Why do we care?
To determine where to take the decision or where to.
Yes, that's excellent, because we really talked about that. Woo! So you've taken this into a new area entirely.
Flying squirrel.
Okay, so you're applying for a conditional use permit to build a Burger King. That's where I always go. Never eaten this place anymore, but it's a use that's allowed conditionally. It's in a residential district. Fast food establishment. And you go in and you file your application, you file all the reports that are required to go along with it, the geotech, the traffic engineering studies, and everything. And they said, yep, you've got a complete application, we'll schedule your hearing with the planning commission in 2 weeks. And it's probably going to be a month and a half because you've got to get the notice provisions out, right? And notice happens, you go out, you go to the hearing, and people, all the neighbors, show up, pitchforks and torches. And they vote you down. planning commission, what options do you have? Yeah. It's really a question for you. You brought it up. Come on. You were on a roll. Let's go.
So, will they vote it down based on the public's opinion?
Let's say they did. It's going to be just like from the midterm. They did one after another. Everybody got up and stood up and said, I don't like it.
So, yeah, I guess then you I guess take to court, and before that, and you could prove that you met the requirements that were
And to whom would you prove that?
to the planning commission makes the reference to the.
In this case, it's an administrative action. So if planning commissions make recommendations to city councils on legislative actions, per Blue Month, we read that section. But this is an administrative action. And in Salt Lake City, if you read this, the planning commission makes the determination, not the recommendation, the determination on conditional use plans. Are you done? You say, oh, okay. Sure. I mean, that's one option. That is one option. Or there'd probably be more like, oh, what the heck with you? I'm going to go out and get drunk. That's one option. Another option would be
Well, to show that you've got the requirement. And
to,
then
yes.
it's allowed.
And how do you do that? Through an appeal. An appeal. And you say, well, he said court. There's a distinction here. You are given the right to appeal. And this is quasi due process. It's not listed, it's not one of those 4 due process, procedural due process elements that we talked about last time with design. There isn't a right to appeal that's listed there. But it's quasi constitutional, quasi implied by the due process. And it's different from just going to court. Because in this situation, at least in Salt Lake City's situation, to whom do you appeal? To the city council. Or actually, that's changing now. They're now getting an appeals officer. Yeah, Craig Call's doing this work now. So I think they've split some of it up. Some of it still goes to the city council. Most of it goes to an appeals officer. But you have the right of an appeal. And this is guaranteed in addition to being implied by the due process clause. Bludma requires that every municipality have a land use decision-making authority that makes administrative decisions, makes decisions on administrative matters like conditional use permits. And they must also have an appeal authority. And guess what? They can't be the same person. Isn't that nice? They actually spelled that out for us. By the way, the appeal authority can't be the same person who just made the decision that you're now appealing. So while it's kind of funny to start with appeals as the first thing, you mentioned it, so we'll deal with it here. If it's an administrative action, you have the right to appeal. Absolutely. What if it's a legislative action? Let's say it's this Mapleton City Council decision to adopt this new zoning district. It's a new zoning district. It's what we call a floating zone, meaning that it could be applied anywhere in the city. It could be applied, theoretically applied to the entire city. Not likely to happen, but what? It's making law, it's broad application, potentially affecting a lot of people. Okay, it's legislative. You don't like it. You're a member of the Friends of Maple Mountain. You think it stinks. You want to do something about it and eventually get around to the idea of putting it on the ballot. But before you do that, you're thinking, what are your options? Can you appeal it? Why not?
It's legislative.
It's legislative, right. Utah legislature adopts a new standard for, I don't know what, chewing gum. only sugarless gums are now allowed in the state of Utah. That's you know they've been channeling Mayor Bloomberg in New York and their concern about public health and the amount of sugar that the citizens of Utah are ingesting, and they want to make sure that people are healthy here and that they don't consume too much sugar. So, sugarless gum, that's now the state law. Only sugarless gum passed by state legislature. You think that's ludicrous. That's dumb. This is not a legitimate matter of government concern. It is not, in your opinion at least, within the government's authority to regulate for health, safety, and welfare. In other words, it's a violation of the substantive due process, right? And so you want to get it overturned. What's your option? Is there an appeal authority?
Yeah, court.
Well, but it's not an appeal. It's not an appeal. Yeah, you sue, you go to court and you sue the state and you say, this statute is unconstitutional. It's invalid. So and you say, well, okay, so what's the difference here? Going to a court, filing an appeal. It's very, very different. Because in the appeal, using the hypothetical that Darby and I just spun out, in the appeal, you're asking for some other body to review how an existing law, was applied to a particular set of facts. And in this particular situation, it appears that there is not substantial evidence in the record to support the denial of the permit. You're not saying that it's unconstitutional. You're not saying that it's invalid or it violates some sort of basic human right or property right. You're just saying you didn't correctly apply the law. There's not adequate evidence in the record to support your decision. That's a very different thing to be asking. And so that's why you have a right to an appeal, because you're contesting something very, very different, usually, than when you're disagreeing with something that's serious. So this is one of the reasons why making this distinction is important. There's another case that I sometimes have students read in this class. It's a very similar set of facts. It's a nonprofit organization down in Beaver, Utah, that's contesting a series of actions taken by the county with respect to a proposed destination resort up in the mountains outside of Beaver. Golf course, and clubhouse, and condos, and I don't know what all. And how did they go? They took the action. The county, and then the citizens went to the county clerk to file their paperwork to go out and collect signatures to put the decision on the ballot. The county clerk refused to accept their paperwork because, according to the county clerk, it was an administrative action. And as we all know now, you can't put an administrative action on the ballot. Not appropriate. And so, okay, if it's an administrative action, then we'll appeal. They filed their appeal, and the appeal authority said, no, you can't appeal this. This is a legislative action. And you can't appeal a legislative action. So they went to court, and the court said, wait a minute, county, which is it? You can't, have it both ways. Okay, what other consequences, what other outcomes fall from the distinction between legislative and administrative? Compensation. How so? You can have your land taken both ways. So actually, there's no distinction. And I've not made much of this because this is mainly for the lawyer types. But if you're challenging the law on its face, as opposed to how it's applied, and you're challenging it based on the legislative action, you're challenging it on how it's applied to your particular property, and it's in the context of an administrative action. In either case, it can have takings effect. So, no distinction. Let's try. Yeah.
The number of people it affects, administrative, with a very few number of people.
Well, yes, and as we were talking about before, that's how we distinguish between legislative and administrative, and that is important. What I'm asking is, after we've already decided that, after we've already figured out how to make the determination between these two categories, what difference is in it? Why do we care? So, Darby has stumbled into a distinction he didn't know he was stumbling into. Okay?
Findings of the result. I mean, the administrative action applies to this case this time, but they could do it again, and if nobody appealed it, then it could go through that. Whereas in a legislative action, if you determine that this law is wrong, then it gets 86.
Sure.
Sure.
Absolutely. I mean, from a kind of broader public policy perspective, yeah. In terms of legal consequences, you're thinking far too real world. Now, what we're asking is, what are the legal consequences? What are the procedural consequences? Pump there a little bit for that adjective. Procedural consequences. Yes, procedural due process, right? The whole Fasano thing. Right? If it's administrative, you get notice, you get a hearing where you present evidence, you rebut testimony, you get an unbiased decision maker, you hope, and a reasonable result, you also hope. With legislative, do you get any of those things? Not from the Constitution. At the municipal level, LUDMA will require you to follow certain minimum procedures for legislative action, like the one we've already referenced about having the Planning Commission make a recommendation on legislative issues, at least for planning and zoning, before the city council makes a decision. That's what something that LUDMA requires. But the due process clause is not, the Constitution is not. And so, from, again, strictly a constitutional perspective, the process, decision-making process that's required is for legislative only what the statute requires. From an administrative context, it's what the statute requires, plus it's underlain by the requirements of the due process clauses variously interpreted by courts like the court in Fasano. Now you might reasonably ask, does LUDMA, do the procedural requirements in LUDMA, in the state statute, meet the requirements of the due process clause? In other words, if you just follow LUDMA, is that enough? Or you also have to be worried about what the Constitution requires, maybe in addition to LUDMA? And the answer is just follow LUDMA. For those of you that just want the simple, practical application that you're going to use when you're out there in practice, just follow the state law. And of course, how it's been incorporated, hopefully, and internalized into your local zoning. But you guys are all students still, right? So we care about this theory. So, okay. So that's the decision-making process. What else? Why else do we care about whether something's legislative or administrative? Oh, you guys really are tired. We just got done reading and talking about a case. Biggest distinction is delegation. Now, delegation, administration, consent. And what's this another way of saying? Referenda.
Yeah.
Right?
Sorry.
Like I said. And Jen's like, just maybe not talk legislative actions, we refer to non-elected people, to the people. Right? But not administrative. And I suppose if you want to read some sort of live into the Vulcanic case, you can say consent provisions. I erase that, but I'll take that up. Meaning neighborhood consent. Yeah, Sean?
Like the nature of the remedy part of this, like the legislative action require maybe payment of some administrative action, the remedy that would require the different things to.
Not really. That's kind of following on what Ahmed was saying. Not really. No, I mean, the difference in remedies falls along other lines. So, for example, nuisance. If you are suing for a nuisance, is it enough to get money? Generally, no. If you're suing for a nuisance, you want the darn thing to stop, right? Which is a different kind of remedy, a mandate. Your court order ordering that guy to put his dog indoors after 10 o'clock. Whatever it is. It's annoying. You know, just having the guy pay $5 for every time he leaves the dog out after 10 o'clock. No, you don't care about it. You know, money's, you know, $5 is $5, but still, a good night's sleep, that's priceless. So that's, like I say, and if you are contesting the validity of a piece of legislation like Chevron was doing in that Hawaii case, the Hawaii gas station case, getting payment out of the state isn't really what you're after, right? You want the validation of the law because you don't believe it comports with the principles of substantive due process. It's not, it doesn't effectively promote a legitimate governmental purpose. So you can't ask for money. On the other hand, if you're David Lucas and you think shoreline protection, beach protection, that's all okay by me. I love beaches. You want to build a house, right? I'm next to one. So I'm all about protecting beaches, but you gotta let me build my house. And if you don't, fine, pay me for it. That's a very different remedy. So the difference again falls along kind of the theory of your complaint, not on whether the action is necessarily administrative or legislative. But on this consent thing, back to the Vulcan, I suppose we can say the creation of law is you cannot create law by neighborhood consent. So it's kind of opposite of referendum, right? You can't create law by having the neighbors decide on where the setback line is, right? So this is not allowed, but you can waive the application of certain laws through approval of the neighbors, and so I suppose you can say that. So it's kind of the flip of the referendum. Well, these are the big distinctions. There are some other ones, but as far as this class is concerned, this is the reason why we spend as much time as we do on trying to figure out the difference between these two and why people at APA spend as much time as they do trying to figure out this. Okay, so that's that. So we are going to finish quickly. Whoop it up for the next 8 minutes. So on Tuesday, we're going to change gears and focus in on First Amendment law, freedom of expression, specifically on sign ordinances. There are many other things that the First Amendment has to say to planning and zoning. Freedom of religion issues. Freedom of expression issues beyond signs. There's the whole issue of sexually oriented businesses. I know that you're disappointed we're not going to get to it's not to say if you're practicing planners that you won't face those in practice. You will, probably will. Those are recurring issues that municipal planners have to deal with. But you'll figure it out when you get to it. You're much more likely to have to deal with sign issues. Sign issues come up again.